Despite long-term recognition of the problem of pendency of cases in the courts, limited progress has been made in reducing their number. What are the possible reasons for such a scenario? Suggest a framework of measures that can be taken to address this issue. Approach, introduced by giving a brief description of the statement, justice delayed is justice denied. Mention the reasons for long judicial pendency in disposing cases across India. Provide factual information to back the same. Suggest measures to reduce judicial backlog. Answer: more than 22 million cases are currently pending in India's district courts. 6 million of those have lasted longer than 5 years. Another 4.5 million are waiting to be heard in the high courts, and more than 60,000 vote. In the Supreme Court, according to government data. These figures are increasing according to the decennial reports. The following causes have been identified for pendency of cases: litigation explosion, inadequacy of the staff attached to the high courts, inordinate concentration of work in the hands of a few members of the bar, lack of punctuality among judges, inadequate supply of the copies of judgments and orders, and so on. Despite recognition of these causes, limited progress has been made in reducing pendency of cases due to the following. The number of judges in the country is inadequate to cope with the staggering pendency of cases in different courts. The rise in the number of cases has not been matched by an increase in the number of judges. There are 10 to 12 judges per million people in India. In developed countries, there are 50 judges per million people. However, increasing the number of judges is not the only answer. Some urgent institutional changes are called for. The critical test is not the judge population ratio but the judge docket ratio. Docket refers to a list of cases to be tried and is an accurate indication of the workload of a judge. In India, the docket ratio per judge is 987, whereas it is 3,235 per judge in the United States of America. The answer perhaps lies in effective court management, which has not been seriously attempted at by the Indian judiciary. For example, computers have not been used adequately to improve court management. Even though Section 301 of the Code of Criminal Procedure provides for the holding of trial proceedings expeditiously, it is an open secret that there is enormous delay in the disposal of cases because of frequent adjournments. The glut of cases in the lower courts is where the root of the problem lies. The number of courts still do not have data under the date file column, the most crucial piece for identifying delays. The proportion of cases that are stuck pending police investigations has little bearing in the ability of the courts to speedily finish trials. For instance, in Gujarat, where 92 out of every 100 cases are pending before the court, only 11.5% are waiting for police investigations to be completed. On the other hand, in Assam, where 80 out of 100 cases are waiting to be picked up the court, about 59% of cases are awaiting police investigations. Inadequate strength of the police force has also played its part in the pile-up of cases before the courts. Measures needed to reduce judicial backlog. Annual targets and action plans must be fixed for the judicial officers to dispose of old cases where accused is in custody for over 2 years. Quarterly review of judicial officers' performance to curb malpractices like hasty disposal which undermine the quality of justice dispensed must be made. Expeditiously filling vacant posts, improving court infrastructure and setting standards of judicial recruitment examinations are other measures to improve the quality of district judges. Further perceptions of irregularities in judge selection deserve consideration. In this context, the National District Judge Recruitment Examination mooted by the Supreme Court must be given the serious thought. Incremental measures like restricting adjournments, curbing summer vacations, and audio-visual recording of court proceedings along with real-time data monitoring of case status will produce a transformative effect. Case flow management (C&M) rules can be incorporated by looking into the recommendations of committees formed by the Supreme Court, such as the Justice and Jagannath Reddy Committee. Encouraging alternate dispute redressal mechanisms such as arbitration, mediation, conciliation, and law caveats along with fast-track courts. Separation of traffic cases from ordinary courts. Improve the quality of subordinate judges at the level of recruitment as well as on-the-job training. Implement the concept of evening courts where the services of the retired judges may be taken along with the law graduates. It would be beneficial in two ways: help training the young incumbents and reducing the pendency. To conclude, other states should follow the footsteps of Haryana, Chandigarh, Punjab, Himachal Pradesh and Kerala, where cases pending over 10 years have been reduced to 1% of the total pendency. In addition, the recommendations of the 245th Law Commission report on arrears and backlogs, creating additional judicial womanpower, must be implemented. 13. Despite the phrase due process of law not being included in Article 21, the Supreme Court, over the years, has adopted the doctrines of procedural due process and substantive due process into Indian constitutional law. Comment. Approach. Giving a brief account of Article 21, bring out the difference between the procedure established by law and due process of law. Then give reasons due to which due process was not incorporated into the Indian Constitution. Bring out various judgments to establish the facts that Indian judiciary over the time has established its conformity towards the principle of due process over procedure established by law. Answer. Article 21 of Indian Constitution provides that no person shall be deprived of his life or personal liberty except according to the procedure established by law. Procedure established by law. The positive law concept means that a law that is duly enacted by the legislature is valid if correct procedure has been followed. As incorporated in the U.S. Constitution, due process checks if the law is fair, just and not arbitrary, thus ensuring a fair treatment. Substantive due process prohibits the government from infringing on fundamental constitutional liberties. By contrast, procedural due process refers to the procedural limitations placed on the manner in which a law is administered, applied, or enforced. Thus, procedural due process prohibits the government from arbitrarily depriving individuals of legally protected interests without first giving them notice and the opportunity to be heard. The Indian Constitution, by incorporating procedure established by law, adopts a healthy synthesis of parliamentary sovereignty and judicial supremacy. However, despite the textual choices of the framers of Indian Constitution, due process found a backdoor entry into Indian constitutional interpretation in late 1970s through the right to equality. Until the decision in Maneka Gandhi case, the view which prevailed in the Supreme Court was that there was no guarantee in the Constitution against arbitrary legislation encroaching upon personal liberty. This case overturned the majority in A.K. Gopalan versus State of Madras, where the majority decision adopted a narrow interpretation of procedure established by law. Contrastingly, the Maneka Gandhi case took the view that the law coming under Art. 21 must also satisfy the requirements of Art. 19. Once the test of reasonableness is imported to determine the validity of law depriving a person of his liberty, it follows that such laws shall be invalid if it violates the principles of natural justice. Over a course of judgments, the court indicated that due process has firmly become a part of the Indian constitutional law, recently reflected in judgments such as Selvi versus State of Karnataka, where constitutionality of investigative narco-analysis was challenged, held it to be permissible only with the consent of the subject. Under wide construction of Article 21, judiciary's view on issues such as cap punishment, custodial death, right to die, right to education, etc., gave supremacy to due process over procedure established by law. 14. Can we say that cooperative federalism in India has strengthened in the post-liberalization era? Give reasons in support of your answer. Approach. Give a brief introduction about federalism and cooperative federalism. Then highlight the factors that have led to strengthening of cooperative federalism in the post-liberalization era. Give a brief conclusion regarding need of cooperation in the wake of liberalization. Answered. Federalism implies division of administrative, financial and legislative powers between union and states, while cooperative federalism implies that they share a horizontal relationship where they cooperate with each other in larger public interest. Our polity started on a cooperative model after independence, but successive governments with strong prime ministers at the center and regional political parties in some state led to confrontational type of relationship. However, post-1990 or post-liberalization era, various factors led to strengthening of cooperative federalism. And a single-party rule at center has diluted the prime ministerial form of government. Thus, union governments are not as powerful as they were earlier. The emergence of coalition government at center has made it difficult to misuse constitutional provisions such as 356 etc. for selfish political reasons. Dependence of union government on support of regional political parties has helped regional leaders to think from all India perspective and union to think from point of view of regional parties. Thus, less confrontation and more cooperation. Presidential activism. Since 1990 onwards, successive presidents have become proactive in ensuring constitutionalism and unafraid of using discretionary power in case Council of Minister misuses constitutional provisions for selfish political reasons. Judicial activism. Since 1990 or XSR by my case has ensured that union government don't misuse constitutional provisions. This has provided a sense of security to state governments. Implementation of 73th and 74th Constitutional Amendment. He has also focused on union, state and local relations unlike union-state relation only earlier. Earlier states were demanding more powers from union without doing same for local government, but now states are more accommodative to the complex dynamics of union-state relations. Active media. With explosion of electronic media after liberalization and spread of social media in recent times, it has become very difficult for any government to adopt anti-democratic measures like dismissing state governments. Changed political culture. People, with increasing awareness about their rights, are unwilling to accept governments which adopt confrontational approach towards center for political reasons, forcing states to behave in a more responsible manner. In fact, recent government initiatives affirm the move toward cooperative federalism. The replacement of planning commission with NITI aid symbolizes strengthening of cooperation between center and states. Though implementation of GST is significant movement towards cooperative federalism in taxation, GST Council provides the institutional framework in this context. The recommendations of 14th Finance Commission and its implications also augur well for cooperative federalism by providing more fiscal space and agency to the states. The restructuring of centrally sponsored schemes (CSS) is also a move in consonance with the broader developments in this context. Both union and states have been forced to come together to make economic reforms and social schemes successful. Further, the forces of liberalization along with information technology revolution and knowledge revolution are making the diverse and pluricultural society of India even more complex and interdependent. In fact, we are moving towards competitive federalism, where states not only cooperate with center but also compete with each other for investments and budgetary support based on their performance. Thus, the success of reforms depends on political stability, policy certainty as well as adaptive approach of the governments. It also needs uniform policies between different tiers of governance. This makes the concept of cooperation not optional but necessary. 15. Faulty regulatory policies can have a severe adverse effect on the efficient interplay of market forces and end up harming public interest. Examine in the context of systemic issues pertaining to regulatory environment in India. Approach. Give a brief introduction about the regulatory framework in India. Give systemic issues in regulatory environment in India. Then give some examples when faulty regulatory policies had a severe adverse effect on market forces and thus public interest. End with a short conclusion. Answer. Regulatory functions are one of the important functions of government. With liberalization, globalization and rolling back of the state, it becomes even more important to have adequate regulation to ensure larger public interest. Thus, regulatory framework is put in place with an objective of increasing the efficiency of the process, procedures and overall sector or market. However, at times, regulations inadvertently lead to restriction of competition for e.g. railways and coal India as well as inefficiency in markets for corrupt practices. In Indian regulatory environment, there are some systemic issues as discussed in following points. Absence of a common regulatory philosophy have made it easier for the political constraints and ministerial preferences to dominate the evolution of regulatory institutions as well as reform agenda. The lack of autonomy to regulatory authorities. It is an uphill task to ensure preservation of independence as well as maintaining accountability of regulatory bodies. Overlapping functions. Due to lack of clarity in statutory laws itself leads to turf wars between different agencies such as SEBI, Trade and Competition Commission of India, etc. Problem of overregulation. For example, Number of procedures to start a business is 12 in India, while the number is 5 for OECD countries. Large number of regulation and poor capacity building leads to slack enforcement. Absence of regulatory impact assessment. There is lack of independent third-party evaluation of effectiveness of regulatory policies. Outdated regulations that continue to remain on the statute book. Other issues. Investment conditionality, FDI limits, restrictions on acquisitions, pricing control, labor laws, etc. These issues in regulatory environment as well as faults in regulatory policies ends up having a severe adverse effect on interplay of market forces and harming public interest. This can be seen from the following examples. Sudyam scam. This scam was a jolt to the market as well as all the stockholders, which highlighted the need for better regulation among corporates. Urban Land Ceilings and Regulations Act 1976, created with an objective of freeing up land for housing project, had to be repealed because it was found that exemptions on ground of public interest were used by target owners to prevent selling off their lands to government. Loss to public exchequer. For example, lack of effective regulatory policies for PPP led to fixing of user charges in a non-transparent manner, as pointed out by CAG reports. Lack of sound public procurement system leads to high leakages in the PDS system and procurement of substandard medicines, etc., which harms the public interest. However, attaining optimum regulation is a challenging task, as a balance has to be achieved between individual's freedom and society's interest. Thus, some pro-market competition reforms should be undertaken, which includes least restrictive regulations, opening up traditional public monopoly sectors, separating policy-making, regulation and operations, competition neutrality between government-owned and privately owned enterprises, and dismantling restrictions on interstate competition.